Hello, everyone, and welcome to today's webinar. Accuracy is everything. UCC Financing Statement Debtor Name Essentials. My name is Annie Triboletti, and I will be your moderator. Joining us today is Paul Hodnefield. Paul is the Associate General Counsel for CSC, where he is responsible for advising the company regarding real estate recording, notary, Uniform Commercial Code, and other public record transaction services. And with that, let's welcome Paul.
Thank you, Annie. Yeah, as Annie mentioned, my role at CSC is to provide or to serve as a subject matter resource for all things related to the UCC search and filing process, as well as other areas related to that. And as part of my responsibilities in that position, I participate in the industry. I monitor legislation on a daily basis. I monitor case law. I pay close attention to everything that's happening with the UCC search and filing process. I'm involved with the Filing Officers Organization, IACA, and I co-chair a task force on filing office operations and search logic for the American Bar Association's business law section. In addition to all that, I frequently am on the phone with filing officers around the country at the state and local level with troubleshooting and other issues. So needless to say, I get a lot of information from a lot of different areas, and the funnest part of my job is when I can come out and share that. And that's what I'm doing today. And today I'm going to be talking about probably the most important aspect of the UCC filing process, and that is the debtor name and the importance of getting it right. The stakes are very high. The consequences are harsh for not getting the debtor name correct. And for that reason, I first put together a program like this about almost 15 years ago now, back when many UCC filers were still trying to understand the new revised Article 9 debtor name rules that had taken effect in 2001. Since that time, filers have become much more familiar with those rules. Moreover, the amendments to Article 9 that took effect in 2013 helped clarify the debtor name rules to provide greater certainty for both filers and searchers. So today, perhaps we should expect that everyone now files under the correct debtor name. Well, unfortunately, that is not always the case. And to give you an idea of just how serious a problem it is, I recently conducted a random search on a debtor name character string and then compared the organization debtor names on the records that were disclosed on that search with the public organic record for each entity. And the result of that comparison found that 41% of the debtor names on those filed financing statements did not match the correct name set forth on the statutory source document for those names. 41%. Now, admittedly, it was a small sample. It was less than 100 debtor names. And for reasons we'll discuss shortly, not every debtor name variation will render a financing statement seriously misleading. Nevertheless, each of those insufficient debtor names creates risk for the secured party, and in some cases, a very severe risk. So why more than 17 years after the debtor name rules took effect are filers still making these types of errors and omissions at such an astonishing rate? Well, there's multiple causes. For one, the debtor name rules are not intuitive, and a filer simply can't rely on common sense to arrive at the correct debtor name. Another is that filers frequently take shortcuts to determine the debtor name without realizing the risks that are involved. There's other reasons as well, but regardless of the reasons for these errors, it demonstrates that there is an ongoing need for education regarding UCC debtor names, and therefore that's what I am going to provide today. Specifically, this presentation will begin with some essential concepts to help understand the Article 9 debtor name rules and the underlying policies. Next, I'll review the standards for sufficiency of a debtor name for purposes of the financing statement and the role that the filing office standard search logic plays in the process. Then I'll explain the name rules by the type of debtor and how to correctly enter the debtor name on the UCC record. And finally, we'll take questions at the end of the program. So for now, we'll go ahead and get started with the essential concepts. Most important thing to understand about the there's some important things that it's necessary to understand about the debtor name rules under Article 9. The first is the importance of correct debtor names. Well, the courts have shown a tendency to tolerate harsh results when it comes to errors in debtor names. And in fact, any error in a debtor name can render a financing statement seriously misleading. And if it's seriously misleading, a financing statement that fails to provide the correct name of the debtor is going to be seriously misleading as a matter of law. What that means is that the court gets to decide, not a jury or anything like that. Next, it's important to understand what the purpose of the debtor name on a financing statement actually is. It's not always what people imagine. Some people presume it's there to identify the debtor. Others might believe it's there to communicate information about the debtor or indicate the debtor's capacity. But in fact, the sole and exclusive purpose of the debtor name on the financing statement is to allow retrieval of the record so that searchers can find the record using clear and consistent debtor name rules. As I mentioned during the introduction, the debtor name rules are not always intuitive. And that's because the debtor name required for purposes of the financing statement may not even be the name of the actual debtor. It may be a name used to represent the debtor for expediency in the search and filing process. So bear in mind that the sufficiency rules are designed to facilitate searches, not to communicate information about a debtor name. Now, when it comes to providing the debtor name, the burden is on the secured party to get the debtor name right. That's because it's not the searcher's responsibility to figure out what debtor name or names or name variations they need to search. They need to just look up the correct name and do their search that way. So the burden is on the secured party as the beneficiary of the security interest. Also, filing offices index the debtor name exactly as it appears on the financing statement. What that means is that when they receive a financing statement, the filing office will type it in to the searchable index exactly as it's set forth in the UCC record. And everything in the name field winds up in the searchable index, whether the filer intended it to be included or not. So it is important to understand that anything that goes in the name field is the debtor name. Another important concept to understand is that the debtor name is not provided unless it's in the name field. And this is because filing offices are not going to index names unless they appear in a name field, because the only way that they know that it's a debtor name is if it is in the name field, either of the written form or its electronic equivalent. And in fact, if they're not in the name field, they're not going to wind up in the searchable index. And as a result, they're not provided, and they won't be a debtor name by which the financing statement can be searched. Also important to understand that organization and individual debtor names are stored separately. There are different debtor name fields in most state-level filing office UCC systems. And because they're stored in separate database fields, they can't be searched in the same database field. The search logic, they use different search logic for organization and individual names, and the search logic that's applied will depend on whether it's searched as an individual or organization name, and it will only search the field that corresponds to the type of name being searched. In other words, a search of an organization name is not going to pick up matches that were provided in an individual name field. So there's this different search logic, and it's applied differently. There are a few filing offices out there that do go ahead and store everything in one database field. These are typically land record offices, but Florida does it as well. And what you'll see is they'll enter individual names by last name, first name, middle name, rather than using separate fields for all those. But those are in the minority at the state level offices. Next, we can move on and talk about the debtor name sufficiency rules. The debtor name sufficiency rules are controlled by Section 9503A of Article 9. I see there's a little bit of latency on the slides, so excuse me a second while they catch up. But 9503A of Article 9 is what controls the sufficiency of debtor names. These rules are based on the type of debtor and in some cases based upon the type of collateral. So 9503 sets forth those rules of the debtor name for purposes of the financing statement. If the filer fails to provide the correct name of the debtor, then that's a problem, because under 9506B, if the debtor name provided on a financing statement doesn't comply with 9503A, then the financing statement is seriously misleading, and it is not effective to perfect the security interest, with one exception, and that is there is a savings clause in 9506C. Note this is not a safe harbor, it's a savings clause. I'll explain why in a second. But under 9506C, if a search of the correct debtor name of the in the filing office records using the jurisdiction standard search logic would disclose the financing statement that fails to sufficiently provide the name of the debtor, then that insufficient name doesn't render the financing statement seriously misleading. So it's important to understand here that strict compliance with 9503A is required, or it has to show up on a search conducted in compliance with Section 9506C. So in summary, when it comes to sufficiency of a debtor name, the debtor name either has to strictly comply with Section 9503A, and I mean strictly comply. It's got to be exactly the same as set forth in the statutory source document. So it requires an exact match to the debtor's correct name for purposes of the financing statement. Now, it doesn't matter how the filing office indexed it. What matters is whether or not it is an exact match on the financing statement itself. Now, if it doesn't exactly match, if it doesn't exactly and strictly comply with the debtor name rules, then the financing statement will only be sufficient if a search conducted under Section 9506C would disclose the record. And that means it has to use the jurisdiction standard search logic. So we've got the two standards. Either it has to strictly comply with 9503A, or it must show up on a search using the jurisdiction standard search logic on Section 9506C. And to understand what type of protection Section 9506C really provides, it's important to understand the model standard search logic. And so I'm going to explain that a little bit here. First, the model standard search logic was developed as part of the revised Article 9 drafting process back in the 1990s. The idea was that because the debtor name rules were changing to a more precise standard, that the search logic should help compensate a little bit for good faith minor errors in things like spacing, punctuation, ending noise words, the at the beginning of the name, and that type of thing. And the way it does it is through a normalization process that's set forth in the model administrative rules for Article 9, which are promulgated by the filing officer's organization, IACA. Here's how normalization works. When somebody provides a financing statement and files it at the filing office, what happens is the filing office computer system runs it through a multi-step process. The first thing it does with that name is it takes the name, makes it case neutral, then it removes punctuation. It strips out ending noise words, which are words, they're words, phrases, and abbreviations that indicate an entity's type. Then it will strip out the from the beginning of the name if it appears there and delete spaces. And what you're left with is a string of text derived from the name on the financing statement. Now, when somebody conducts a search, the name that is being searched is also normalized, and only exact matches are reported at that time after both the name on the financing statement and the name on the search string is normalized. And this process is going to normalize all characters in a debtor name, not just those that that it would recognize. So anything that goes in the name field is going to be organized or normalized, and the result is that if there's any deviation at all, there's a risk that they won't normalize the same way. And here's an example of how that works. This is an actual example out there. We have the name on the public organic record, which is the source of the debtor name for a registered organization. Pitt Pipeline Company, Inc. Somebody filed a financing statement on this debtor, and the name on the financing statement looks the same, but if you look very closely, you will see that they made a typo in company. So they left out the P in company. The result is it's not the correct name of the debtor. Because it's not the correct name of the debtor, the financing statement will only be sufficient if a search on the correct name of the debtor would find it. And the search is going to depend on whether it's normalized correctly using the jurisdiction standard search logic. Well, if we look at how these two names are normalized, you'll see the name provided. The first step is it makes it case neutral. Then it strips out the punctuation, the noise words, the deleted spaces, and you're left with the normalized name. Now, a search on Pitt Pipeline Company, Inc. is going to result in the normalization stripping out Inc. and company and the punctuation and everything. But it's not going to find Pitt Pipeline Company without the P, because without the P, it doesn't say company, and the search logic will not dismiss that as an ending noise word. So the normalized string will include that misspelled word. The two normalized names do not match, so a search on the correct name is not going to find the name with the spelling error, and that will render the financing statement seriously misleading and not effective. Now, there are some limits to what model search logic can do. For example, there are some performance differences with standard search logic, and it can vary a little bit between states. For example, some states don't disregard all ending noise words. Some disregard just the last ending noise word. They wouldn't disregard company, Inc. They just disregard Inc., while other states would disregard both company and Inc. Many states work off of different noise word lists, and there's other deviations in there. To top it off, there's a number of states that don't use the model standard search logic. They have something else which oftentimes is more precise. Bottom line is, when it comes to deviations in a debtor name, never ever rely on the standard search logic to save an otherwise insufficient debtor name. It's a very risky proposition because you simply can't rely on search logic. It's too iffy. So bottom line, if there's an error in the debtor name, it should be fixed as early as possible. Now I want to move on and talk about the correct debtor name by type. And we'll begin with the most common type of debtor in a commercial transaction, the registered organization. Now, Registered organizations, that's a defined term in Article 9 that includes an entity formed or organized by the filing or issuance of a public organic record or the enactment of legislation. A registered organization debtor name is sufficient only if the financing statement provides the name stated to be the name of the organization on the public organic record most recently filed with or issued by or enacted by by a jurisdiction. Now, public organic record is defined in Article 9 as well, and it includes the record initially filed with or issued by a state or the United States that forms an entity. It includes legislation that creates an entity, a record of a business trust that's required to be filed under state law. It also includes subsequent records filed to amend or restate the name. Examples include the Articles of Incorporation, for example, a statute that forms a corporation. There are corporations formed by statute. And a declaration of trust that might need to be filed in order to comply with a statutory business trust law. There are some things that are not public organic records that are sometimes mistaken for them and used as the source of a debtor name. These include a certificate of good standing or the state's online business entity database. Unfortunately, these are not records that can be relied upon because they may not match the name set forth in the actual public organic record. And there can be deviations. In fact, there are frequently deviations there. So here's an example of how to use a public organic record. We have a corporation known as Ben Realty Group. That's the name stated in the public organic record as the name of the corporation. Therefore, that name must be the name that is provided on the financing statement. And in this case, that's what happened. Now, Ben Realty Group changed its name at some point. It filed an amendment to the Articles of Incorporation and became BRG Group, Inc. Well, by doing this, now, after February 23rd, 2017, the most recently filed public organic record is the amendment that restates the name. And BRG Group is the name that must appear on any financing statements filed after that time. Also, the debtor name must exactly match the name shown on the public organic record. The financing statement must provide it exactly, even if it doesn't look quite right. For example, we have an example here where in the articles, whoever filed the articles put the ending noise word of the debtor in quotation marks. That doesn't quite look right, but that's exactly how it should appear on the public organic record. Or I'm sorry, that's exactly how it should appear on the financing statement if that's the way it appeared on the public organic record. Here's an actual example of how important it is to get it exactly correct. In Wisconsin, there was a record filed with the Wisconsin Department of Financial Institutions on ISC Inc., and there were two financing statements filed on ISC Inc. And if you look closely, one of them has an extra space in the name. Well, believe it or not, that was enough to render the financing statement seriously misleading and not effective because the Wisconsin Department of Financial Institutions standard search logic does not disregard spaces. With the extra space in the name, it's not the name of the debtor. And because of the extra space and the fact that the search logic in Wisconsin does not disregard spaces, a search of the correct name did not find the name with the extra space, and as a result, it was seriously misleading and not effective. I'm going to show you some examples now of financing statements that have provided incorrect debtor names. There was a case that arose out of Texas a few years back, Jim Ross Tires, Inc. The secured party added the DBA following the correct name of the debtor and argued that once you get the correct name in there, anything after that should be disregarded. The court correctly pointed out that no, any extra information in the name field will effectively prevent it from being searched, and as a result, it won't be disclosed. So the extra text is part of the name, and by adding that, the secured party made it seriously misleading and not effective. Obviously, a typo, like I talked about earlier, will render a financing statement seriously misleading because it won't disregard the at the beginning of the name if the is misspelled. Also, punctuation matters. In this case, the debtor name on the financing statement was KWM Electronics, but the actual debtor name on the articles had periods following the initials. Those did not make it onto the financing statement, and as a result, it's not the name of the debtor. And the problem is that in Utah, where it was filed, Utah does not disregard punctuation. It requires a more exact match, and consequently, it was found seriously misleading and not effective. So some registered organization name tips to provide when you're filing on a registered organization. First of all, it's important to conduct thorough due diligence. Any shortcuts carry risk. Don't, going to the database rather than the articles of incorporation, for example, is a risky shortcut because it may omit punctuation or words or things like that. Be sure to use the name on the record and use it identically to the way that it appears on the public organic record. So put it on the financing statement with the same spelling, spacing, punctuation, word order, and I even go so far as to say the same upper and lower case. Case doesn't matter that we're aware of at any state-level filing office, and I've yet to confirm any county offices where upper and lower case matter. Nevertheless, I think it's best to be as precise as possible. Excuse me. And never, ever add anything to a debtor name. Never add any explanatory text, descriptive information, things like titles and capacity, because all of these things do nothing but add characters to the debtor name that are not part of the debtor name. They will be normalized, and as a result, a search on the correct debtor name typically won't find debtor names that have this added information. Next, I want to talk about the debtor name when the collateral is administered by a decedent's personal representative, what we used to call decedent's estate. In this type of case, the debtor name is sufficient only if the financing statement provides the name of the decedent and in a separate part of the financing statement indicates that the collateral is being administered by decedent's personal representative. So really we have two requirements here, the name of the decedent and the required indication. These are both name requirements, even though the indication goes somewhere else. So some pointers on this. First of all, remember that the name of the decedent is an individual name. It's the name the person had while they were alive. And the indication is not part of the name. It has to be in a separate part of the financing statement. And as a result, if it is added to the name, it will render the financing statement seriously misleading and not effective. Now, if you look at some examples that I have here, here we have the name provided in the organization name field. It has the indication in the name field. This is going to be seriously misleading and not effective. Here we have the name of the executor. It's the name of the decedent, not the administrator. And again, the indication cannot go in the name field. If it goes in the name field, it becomes part of the name, and it is no longer the individual name the person had. It's now something else, and those extra characters will, in virtually all cases, render the financing statement seriously misleading and not effective. So a few pointers when dealing with this type of debtor name. When you're dealing with an estate-related debtor name like this, number one, remember that the name of the decedent is an individual name. So you determine the correct name to use, roughly following the same procedures as you would for a living person. And that means putting the components of the name in the correct name fields. It means verifying the full name, not nicknames, things like that. Now, of course, you'll see when we get to individual names that it requires the use of the driver's license to determine, in many cases, the correct use of or the correct debtor name to provide for an individual. But for a deceased individual, the driver's license rule really doesn't apply. But typically, the best way to do it is the full first name, full last name, full middle name. Everything should be the full name. There is a safe harbor for the name of the decedent on the financing statement, and that is the name indicated on an order appointing the personal representative. That was added by the amendments that took effect in 2013. So that's a clarification. And of course, the other thing is we need to provide an indication on the UCC record in a separate part of the financing statement that the collateral is being administered by decedent's personal representative. The way to do that on the written form is to use the checkbox in item 5. It didn't fit very neatly on here, so I broke it up into 2 lines. But the checkbox is the way to do it. If you try to put it in the debtor name, that is going to result in a seriously misleading financing statement nearly every single time. Also, if you're filing electronically filed records will typically have the same checkbox available. If there is no checkbox available for an electronically filed record, then go ahead and enter it into the collateral field, state that the collateral is being administered by a decedent's personal representative. But no matter what, do not put it into the debtor name field. If it's put in the debtor name field, it becomes part of the debtor name, and it will cause that debtor name to not match the correct debtor name, and the financing statement will be seriously misleading and not effective. The next type of debtor is for a collateral or when the collateral is held in the trust. Again, for estates and trusts, aside from a trust that is a registered organization like a statutory business trust, the factor used to determine the correct name of the debtor is not the type of debtor, but rather the status of the collateral. So that's the case for a common law trust. And in the case of a common law trust, the debtor name sufficiency rules are, number one, if the organic record of the trust specifies a name for the trust, then the financing statement must provide the name specified. If no name is specified, then the financing statement must provide the name of the settlor or testator. And in a separate part of the financing statement, there must be an indication that the collateral is held in a trust. Now, if the name of the settlor or testator is provided, then there's some additional requirements. That means in a separate part of the financing statement, there must be additional information provided to distinguish the trust from other trusts that have one or more of the same settlors. So the important thing to remember here is, first of all, the only permitted names for a trust, the only names that could be correct are is either the name of the trust, or if the trust doesn't have a name specified, the name of the settlor or testator. Those are the only names that are sufficient. The name of the trustee is not sufficient as the name of the debtor, unless the trustee is also the settlor of an unnamed trust. The additional information and trust indication, if the name of a settlor or testator is provided, that goes in a separate part of the financing statement. It must not be provided in the debtor name fields. If it is provided in the name field, that information becomes part of the name provided on the financing statement, and that string of text will not equal the string of text that represents the correct name of the debtor. The search logic will not find it, and as a result, it will render the financing statement seriously misleading and not effective in many, many cases if additional information is provided. Now, to give you some examples here, trust-related names do tend to be more confusing than other types, and this tends to lead towards a lot more errors in the filing process. In fact, there are so many trust-related errors because of the different forms that trust-related names are oftentimes provided. Let me give you some examples of a number of different ways the same trust can be provided on financing statements. These are all the exact same trust. Every one of them is a common form of a name we see provided on UCC financing statements for the name of the trust, and every one of these is possibly wrong. It could be the DeLuca Revocable Trust or just DeLuca Revocable Trust. We can't know for sure unless checking the organic record of the trust, because without the organic record, the filer is not going to know how to file the financing statement. They will not know whether the trust has a name, or if it doesn't have a name, what the name of the settlor or testator should be. And that leads to a lot of errors. They're not trusting the rules for this type of debtor name. And there are plenty of examples out there that are very easy to find for errors in debtor names when it comes to trust-related situations. For example, we have the Clarence Griffinger Declaration of Trust Agreement. Here, the trust agreement is being named as the debtor. And the trust agreement simply can't be a debtor. An agreement is not a debtor. So they did not provide the correct name. It's probably either it's probably the name of the settlor or testator in this case, based on the form of the name that's provided there. You can't tell without looking at the organic record of the trust, but it would be highly unusual for this type of thing to actually be the name. When the name is provided, generally it's important to provide the name in the correct field, and also to avoid providing anything extra in the name field. For example, we have the name of the trustee provided in the organization name field. A couple of problems with that. First of all, the name of the trustee is not sufficient as the name of the debtor for purposes of the financing statement, even though the trustee may very well be the actual debtor who granted the security interest. This is a case where Article 9 uses a name to represent the debtor rather than the actual name of the debtor itself, just as it does with collateral that's held in, or collateral that's being administered by a decedent's estate or a decedent's personal representative. So the name of the trustee is not sufficient. Likewise, indicating a party's capacity is not sufficient, and providing an individual name in an organization name field is typically not going to be sufficient because it will not be searched correctly using the correct search logic. Even if put in an individual name field, if it has the trustee capacity indication, that will, again, prevent a search of just the last name from finding this financing statement, because that string of text of the correct last name will not find the string of text that includes the capacity indication. The trust of Aaron Newman, under agreement dated such and such. Again, this is a very common way of providing the name of the trust. Yet, if you look at the organic record of the trust, I would be really surprised if it appears that way. And that's because typically it would say something like the trust of Aaron Newman. The name of the trust is the trust of Aaron Newman, not the agreement and the date of the agreement. This is typically descriptive language that makes its way onto the financing statement with the result that it will render the financing statement seriously misleading. And the Joe Techie Inc. as settlor under voting trust agreement dated such and such. The name of the settlor may very well be the correct name to provide, and in the organization name field if the settlor is an organization. But here they've included the statement of capacity, indicating that the party is a settlor is going to be a problem because that's not part of the name. And as I've said over and over again, indications of capacity are descriptive text and are not part of the name. They get normalized as part of the name, and they will prevent the search logic from finding the record. It's important to think of these names as strings of text and not actually names and words. In order to be the correct name of the debtor, the string of text in the name field has to exactly equal the string of text that represents the correct name of the debtor for purposes of the financing statement. And adding anything in there is going to make it so they don't match. It's going to leave it up to the search logic, and the search logic simply isn't going to find it in these cases. Also, this one has included some descriptive language about the trust agreement. That information is simply not something that should go in the debtor name field. It needs to go in a separate part of the financing statement. So as a result of this situation, there are some important things to understand about providing the name of trust-related, or providing the debtor name on trust-related financing statements. The first thing is to remember that the financing statement uses a name to represent the debtor rather than the actual name of the debtor itself. Debtor is a trustee. The name is either the name of the trust or the name of the settlor or testator. And it's always important to start with the trust's organic record, because without being able to view the trust's organic record, the filer is not going to know what name is required. They are not going to know if a name is specified. And by specified, by the way, that's not just describing a trust. It typically means something along the line of, the name of this trust is, much as you'd see for a registered organization in the articles. It should be very clear and specified as to what the name is. If it's not real specific, then the filer might want to consider providing the name a couple of different ways, both the possible correct name of the trust and the name of the settlor or testator. If the name of the settlor or testator is required, it's important to know that there is a safe harbor, and that is the name indicated for the settlor or testator in the trust's organic record. So the filer is going to be protected if they use the name exactly as it appears for the settlor or testator in the trust's organic record. Now, it is important, once the correct name is determined, to provide the name correctly. And that is to enter the name in the field that corresponds to the type of name. This is really important. If it's an individual name, it must go in the individual name fields to be searched correctly. If it is an organization name, it must go into the organization name fields to be searched correctly. In addition, it's also a good idea, if there's a conflict between the type of the actual debtor and the type of debtor name. For example, the debtor is an individual trustee, but the name that's required is an organization name for the trust. You might want to also consider filing as the second debtor the name in the field that corresponds to the type of debtor, just so that if a court ever has to face the issue, that they would have the name in there either way. And the reason why I recommend this, I don't think it's necessary, but there are a lot of respected commentators out there that question whether this might be necessary, and therefore it's probably a good idea to do it both ways if there is that conflict between the nature of the debtor and the nature of the name. But I think it's most important to get the name in the fields that correspond to the nature of the name, and optionally to also file it as an additional debtor in the field that corresponds to the nature of the debtor. Never, ever add any additional information to the name field beyond that which is required by Article 9. That includes any information about the trust or the settlor or the testator, their capacity. Anything like that will almost certainly result in the string of text not equaling the correct name of the debtor and prevent the search logic from finding the record if a search is made on the correct name of the debtor. Also, because that information, the indication that's required, must be made in a separate part of the financing statement, be sure to use the checkbox to indicate that the collateral is held in the trust. It's on the written form and the electronic equivalent. Most electronic filing systems permit a checkbox to make this indication. In those that do not have a checkbox for it, if you're filing electronically and cannot indicate it by checkbox, put it in the collateral. Do not ever put it in the name field. The Article 9 name requirements specifically state that this indication and other information must be provided in a separate part of the financing statement. Now we'll come to individual debtor names and the individual debtor name rules that are out there. During the enactment process of the amendments that took effect in 2013, there was some debate over whether to require the use of the driver's license as the source of a debtor name or whether to make it a safe harbor. And there were some vigorous advocates of both positions during the drafting process, and the drafters finally decided that what they would do is they would offer both up as legislative alternatives, and each state could decide which to enact. The vast majority of states decided to enact what was called Legislative Alternative A, and in this, only the name on the driver's license is sufficient. What this means is if the debtor has a qualifying driver's license, then that is the name indicated on the driver's license is the only acceptable name for the debtor. So in Alternative A states, if the debtor has a driver's license that is unexpired and issued by the state of filing, then the name on that driver's license is the name that has to be provided. If the debtor does not have such a driver's license, then there is a second-tier safe harbor that says if they don't have a qualifying driver's license or state ID card, then they can, the secured party can provide just the surname and first personal name of the debtor. So, important thing to understand here is that in Alternative A states, the use of the driver's license is mandatory if they have an unexpired driver's license issued by the state of filing. Now, most of the states that enacted this provision include language that says if they don't have a driver's license, then the state-issued ID card. So the proper way in those states is to look at do they have a driver's license? If not, do they have a state-issued ID card that's unexpired and issued by the state? And only if they don't have those two, then you go to the second-tier safe harbor. And I believe in the handout materials, we have a flow chart and a chart of the states that have the state-issued ID in their statute. Those are all listed so you can see which state is which. Alternative B was the safe harbor, and in Alternative B, which is the minority rule, and it's only been enacted in about 6 states, and again, those are indicated on that handout chart I described. The driver's license is one form of correct name of the debtor, but also the surname and first personal name or the individual name of the debtor, whatever that might be. Those are all sufficient. But again, only I think 6 states enacted that. There are other jurisdictions that may not have either of these because they haven't enacted the amendments to Article 9 yet. These include the U.S. Virgin Islands, the Pacific Territories, which don't even have revised Article 9 in effect yet. And probably a variety of Indian tribes have enacted secured transactions laws that don't have these rules in effect either. But for the 50 states, D.C., and Puerto Rico, they do have, most of them have alternative A in effect, and as I said, just the 6 out there that don't. Now, it's not as simple as just necessarily looking at the name on the driver's license. In order to use the driver's license as the source of an individual debtor name, it's actually a 3-step process. The first step is to check and make sure it's issued by the state where the financing statement will be filed. The second step is to check the expiration date. It must be unexpired in order to serve as the correct name of the debtor for purposes of the financing statement. If it is unexpired and issued by the state of filing, then it's time to go on to the third step, which is to extract the name from the driver's license and map it to the financing statement, putting the components of the name in the correct fields, bearing in mind that the components of the name may appear in a different order than they appear on the driver's license or on the financing statement. So the driver's license name components and the financing statement name components may have to be mapped a little differently to the correct fields. And by the way, if there is any question as to how to map these to the correct fields, don't be afraid to provide the individual name in more than one way, so that whatever name a court later decides, or whatever way a court later decides was the correct way to extract it, is on the financing statement. Remember that the name on the financing statement is the debtor name for purposes of the financing statement, and that would be the case even if the name indicated on the driver's license has a blatant error. So that name with the blatant error also has to make it onto the financing statement. And I recommend, in addition to that, if there is a blatant error, to provide as an additional debtor the correct name as it would appear if the driver's license was correct. And that's because if the individual were to go down to the DMV and get that fixed, that would be a name change event. And as a result, the secured party would become unperfected for collateral acquired more than 4 months after the name change event, unless it filed an amendment to make the financing statement non-seriously misleading. But if the name is already there, then the secured party is protected against these unexpected name changes. And with a driver's license, part of the issue is a driver's license is not a public record. And unless the debtor remembers to inform the secured party that they have changed their name, the secured party has no way of knowing that they've changed their name from what was on the driver's license to something else. So the only way to protect really against that type of unexpected name change when a driver's license contains an error is to go ahead and file it up front in what it would likely change to. Now, it's kind of a guess because you never know what the final license will be, but it provides more protection than not doing that. So if there are errors like that, by all means, it's a good idea to go ahead and take action to protect against inadvertent name changes. There are some states out there, I am led to understand, that might allow characters on a driver's license in a person's name on the driver's license that typically do not appear on the keyboard. For example, the Enya character in a Hispanic name may appear on a driver's license. The problem is that if the financing statement doesn't provide this exact character, arguably it's not the name of the debtor, and the secured party will be unperfected. So the best practice here is to file the financing statement using that character as one debtor, and then also provide the name of the debtor spelled as it's likely to be searched if the searcher is unable to enter the actual character into the search system. In fact, a filing office may index Pena there as P-E-N-A, even though the financing statement provides the correct character. But that's fine. That's the filing office's doing. The filer's responsibility is to get the name right and not to worry about what a filing office may do to it. But it isn't a bad idea to provide it a couple of different ways to make sure that both the correct name of the debtor is indicated on the driver's license or on there, and also the way it's likely to be searched in case the filing office indexes it differently. Part of that is because when filing officers are confronted with a character that isn't on a standard keyboard like this, they don't handle it in a consistent manner. Some jurisdictions may index it as P-E-N-A. Others would treat that character as punctuation. So it would actually normalize to P-E-A. Others might delete the character entirely. Some might leave it to the indexing clerk's discretion as to how to index it. Regardless, by providing it as a separate debtor in the way that it's likely to be searched, the filer has some control over whether it will show up on a search. There are errors that get made during the filing process when using driver's licenses. Most commonly, this occurs because people don't trust the license like they're supposed to. And there's a case that provides a good example of that. It was called In Re Nay, and it was a case out of Kentucky. There were two financing statements filed. One spelled the middle name as Mark. The other one spelled the middle name as Marked, as in T at the end. Turns out the name on the driver's license was the one with the T on the end. What probably happened here is whoever was filing the financing statement looked at the driver's license, saw the T at the end, assumed it was a typo, and corrected it themselves when they were filing. The only problem is that while the debtor name on that first financing statement may be correct for all other purposes, the name on the financing statement is the name of the debtor indicated on the individual's driver's license. And if that T is on the driver's license, it has to be on the financing statement. And in this case, the financing statement without the T on the end of the middle name was found seriously misleading, because without the T, it's not the name of the debtor for purposes of the financing statement. And the standard search logic of the jurisdiction, when searching on the middle name Marked with the T at the end, did not find Mark without the T. And as a result, that financing statement, due to that tiny error, and actually what the filer probably thought was a good common sense way and an intuitive way to fix a minor error in the driver's license, wound up leading to a seriously misleading financing statement. So the important thing here, when it comes to individual debtor names, first of all, when filing on an individual in an alternative A state, and actually in most alternative B states as well, because the driver's license process works pretty well, begin by confirming the sufficiency of the license. It has to be issued by the state where the record will be filed. You must verify that the driver's license has not expired. And if the debtor doesn't have a license, or if state law allows an alternative non-driver's ID, then use the safe harbor option, which means the surname and first personal name. Be sure to map the components of the name to the correct spaces on the UCC form or its electronic equivalent. That means extracting the name from the driver's license correctly, and don't be afraid to provide as additional debtors different variations of that name in case there are questions as to how the name should be extracted. For example, what if there are 4 components to the name provided? Mary Ellen June Johnson or something like that. What is the first name? What is the middle name? Could it have been a hyphenated last name because the state didn't permit punctuation on driver's license? If you don't know, don't be afraid to provide it more than one way. And then it's also important to preserve evidence because the driver's license is not a public record. The only way to show that it was correct at the time of filing is to keep a copy of the license. One other word of caution on this. The individual name search logic doesn't really disregard any punctuation, spacing, or ending noise words like it does with an organization name. So you should punctuate the name exactly as it appears on the license. If there's no punctuation on the license, for example, you know that the person has a hyphenated last name, but the hyphen doesn't appear on the license, don't add the hyphen because the search logic will not disregard punctuation or spacing like it would for an organization name. For other types of organizations, and this is really anything other than those that I've already covered, it's really left to the filer's best judgment. If the debtor has a name, then the financing statement is sufficient only if it provides the organizational name of the debtor, whatever that may be. But there is no safe harbor for what to look for. It's left to the best judgment of the filer. And for that reason, it's a little bit of a gray area in there. There have been some cases involving this, but bottom line is it really is left to the best judgment of the filer. So the recommendations on this: conduct thorough due diligence into the organization's name. There may not be a single document that can be a source of any other type of organization name, and therefore it may be necessary to file one or more name variations as additional debtors to ensure that the correct name of the debtor makes it onto the financing statement, whatever that might be. Another situation that can arise is, what if the debtor doesn't have a name? Well, Article 9 does deal with this issue. If the debtor doesn't have a name, then the financing statement is sufficient only if it provides the names of the partners, members, associates, and other persons that comprise the debtor. The name must go into the fields that correspond to the nature of the name. In other words, you provide each of these names as if that person was named as a debtor in their own right. So if your debtor is a partnership, for example, it might mean that the individual names of the partners might need to be provided each as individual debtors. Also, exercise some caution. Don't assume that there is a name if there isn't necessarily one. If you can't confirm that an organization has a name or that the debtor has a name, but it might have a name, well, go ahead and provide that name as a debtor, but also cover yourself and provide the names of the partners, members, and others that comprise the debtor, so that whatever a court later decides was the correct way to do it is the way that the financing statement is filed. Next, I want to talk about what happens when somebody figures out what the correct name is, but then provides it incorrectly, because there are ways to go about and file incorrectly an otherwise correct name. And there have been some court cases on this, and I think sometimes the outcome is pretty easy to determine. For example, here we have Stephen R. Voberil. It's an individual name, but it was placed in the organization name field because the organization or the debt was related to an organizational acquisition. So they put it in the organization name field, and it was found to be seriously misleading because it wasn't provided correctly, and because it wasn't provided in the individual name fields, it could not be searched as an individual name. The different search logic applied. The data wasn't even included in the search. When they searched it as an individual name, it didn't even look at organization names. And as a result, it was found seriously misleading and not effective. Here's another example of how to incorrectly provide names. On Exhibit A, there's a long list of debtor names, each one of which the secured party has verified as being correct at a great investment of time and expense. Yet, if somebody looks at how this is indexed, all that's going to be indexed is what was in the contents of the name field. Those provided on Exhibit A are not going to be indexed because they're not in debtor name fields. The filing offices do not exercise discretion about what to provide for debtor names or how to index debtor names. If they just transpose that string of text in the name field into the searchable index, whatever it is. They don't care what it is. They aren't worried about whether it's correct or not. They take that string of text in the name field and they transcribe it exactly into the searchable index. So whatever's in the name field is what's going to go into the index. And if it's not in the name field, it doesn't go into the name, or it doesn't go into the index, with the result that it cannot be searched. The thing to bear in mind about these very long debtor names is that typically a correctly provided debtor name will easily fit within the space provided. And in fact, the filing office may not be able to index the entire text of a long debtor name. Some have up to 300 characters or more. But in this case, this was indexed with the Illinois Secretary of State. I think it was 180, or it's either 120 or 180 characters that they can index. And as a result, this is all that would appear in the debtor name, which is a problem because the only unique identifier in that entire character string, if you read the whole thing, at the very end of the character string, there it states and known as trust number 315. That will not make it into the searchable index. So there's absolutely no way to search this. In fact, this is an Illinois land trust. I'm not sure that this provides either the name of the trust or the name of the settlor or testator, so it probably isn't correct anyway. But the only unique identifier doesn't show up because the name is so long. A very good rule of thumb when filing on any type of debtor name is that if the name doesn't easily fit within the space provided on the form or the viewable area of the electronic record on an electronic filing system, that should be a big red flag that something is wrong with the name. And it's a good idea to go back, check the statute, and verify that the name that the filer wants to provide is actually the correct name of the debtor for purposes of the financing statement. So to sum up some of the best practices in dealing with debtor names, really the most important thing to remember is that the filer should provide the debtor name on the financing statement exactly as it appears on the statutory source document. And that means exactly. Spelling, spacing, punctuation, ending noise words. If the appears at the beginning of the name, that's got to go in there. And as I said earlier, I even recommend upper and lower case match exactly the case used in the source document. In addition to that, remember, never, ever add any information to a debtor name field that does not appear in that statutory source document. Some of the most common errors here include indications of capacity, additional descriptive information, such as the date of a trust or something like that, and sometimes even the name history of the debtor that's listed. This may all be helpful information to a searcher, but the problem is it either won't get to the searcher, or the searcher can disregard it because they know it's not going to be an effective name. And finally, never rely on the standard search logic to prevent any type of error or omission in a debtor name from making the financing statement seriously misleading. Remember, search logic can change or malfunction. If that happens and the filer didn't provide exactly the correct debtor name, I think that and if the record fails to show up anymore, it almost certainly is going to be a risk borne by the filer, not by others. So it is really important to get the debtor name correct. After filing a financing statement, it's a good idea to do a search to reflect, to verify that the name was correctly filed. If any deviations are found, if there's any variation whatsoever, I recommend filing an amendment as soon as possible to ensure that if the search logic is an issue, that the correct name is on the financing statement at the earliest possible opportunity.